I think we're going to get started. Welcome, everyone. I'm Dave Beamstover with United Philanthropy Forum. Glad to have you here for our periodic Ask the Nonprofit Lawyer program. Really pleased to have with us again Jeff Tenenbaum from Tenenbaum Law Group. I always learn something new every time we do one of these calls, so looking forward to the conversation today. And our first question comes from Lauren at Exponent Philanthropy, Jeff. I think this is always an evergreen topic that's worth talking about. What would she'd like you to again clarify about the IRS rule around donations and goods and services, and how to determine how to deal with that when you're accepting donations or when you're getting dealing with program registration fees or other kinds of income.
Sure. And first off, hello, everyone. Nice to see you all, some of you again. As you may know, I'm a nonprofit attorney in private practice in DC. I've been practicing law now for 27 years, all of it exclusively as a DC lawyer in private practice representing nonprofit organizations as outside counsel. 3.5 years ago, started Tenenbaum Law Group as a boutique nonprofit law firm. We now, as of next month, we will have 5 lawyers, and we represent hundreds of different nonprofit organizations of all different types and shapes and sizes and forms across the board: charities, foundations, associations, international NGOs, conservation groups, think tanks, arts and cultural institutions, and we deal with a very broad array of all of their different legal issues. So your question, Lauren, is a great one. It's such a great one that I have a whole article that I wrote devoted expressly to this topic, which Brandon is going to post in the chat. And it's on our website. And also, before I forget, for those of you who are looking for additional resources on the topics we're going to talk about today and any other nonprofit legal topics, we have a wealth of material on our firm's website, tenenbaumlegal.com. We have hundreds of articles, PowerPoint presentations, and a ton of recorded webinars, probably about 75 recorded webinars on all different nonprofit legal issues. So we're constantly adding new material there. So feel free to check that out, or always feel free to email me if you're looking for resources on anything. There's a lot of stuff there. It has a really good search feature where you can search for things. But if you're looking for something and you're not sure, just email me. Happy to, Brandon, if you can put my email address in the chat too. Always happy to provide resources on anything that might be of interest. And then we also, not on our website, but we have a massive library of kind of nonprofit forms, policies, agreements, and other documents like that I'm also happy to always share. If you just shoot me an email, happy to send those kind of things to you. Just today sent one client of ours several different versions of our kind of nonprofit CEO or executive director employment agreement. And I sent another client some of our model releases and waivers of liability for events and things like yoga classes that you might host at a meeting or a conference and other things like that. So always feel free to reach out. But back to your topic. So this all, the question has to do with kind of what are the IRS requirements when someone makes a contribution to a 501c3 organization. So first off, let me kind of take a step back, and I know it's broader than what your question was about, but I think it's relevant. Whenever you think of kind of contributions to, or any sort of payment, contribution, grant to a 501c3 organization, I usually think from a tax perspective, think of 3 different aspects to it. One is, how does the income get treated and booked from your organization's perspective? Is it treated as tax exempt income, or is it treated as taxable unrelated business income? And then even if it's treated as tax exempt income, you have to book it in certain categories, whether it's kind of related to your mission and purpose, what might be called program service revenue, things like income that you receive for conference registration fees, publication sales, other things like that. Gifts, grants, or contributions are another category. If it falls into one of the exceptions from unrelated business income, you have to properly book it as either, say, royalties or corporate sponsorship income or qualified convention and trade show revenue, maybe subject to the volunteer labor exception. And so it's important to understand how you treat that income, obviously to try to keep as much or all of that income free from unrelated business income tax if possible, but also understanding how to properly book it. A second perspective, while you should never and are not allowed to give tax advice or legal advice to donors or contributors, it's always important for you to be cognizant of whether and to what extent the donor or payer can take a tax deduction for their contribution, either as a charitable tax deduction or in some cases as a business tax deduction. And how you structure it can have an impact on that. And obviously that can have a great impact on the willingness or incentivizing of a would-be donor to make a contribution. And we'll get into that in a second. And then the third issue is really what you asked about, Lauren, which is what sort of obligation do you have to provide something back in return, like a charitable gift receipt to the donor? And that's kind of a third and separate issue. That's the issue that's covered by my article. I have another article that I will post in the chat on unrelated business income for nonprofit organizations and understanding some of the main exceptions, like the royalty exception, the corporate sponsorship exception, and the qualified convention and trade show exception, because it's really important for you to understand those three core exceptions so you can try to structure your various programs in a way that take full advantage of those exceptions. And for instance, primary form of unrelated business income that most nonprofits earn is advertising income. But outside of the publication, left side of like the periodical space, like newsletters and magazines, where the corporate sponsorship exception does not apply, there are a number of other instances at your events, on your website, other places where, depending on what sort of recognition or benefits the sponsor is looking for, you might be able to turn what might otherwise be considered taxable unrelated business income, like advertising, into tax-free corporate sponsorship income. So it's important for you to understand those exceptions. But back to this issue. So as the article points out, there are kind of two different requirements that apply to a 501c3 organization when it's receiving contributions. But I should say that one of the things to keep in mind is that these rules do not apply if there's no donative intent. Donative intent is an IRS term that basically means someone is intending to make a charitable contribution as opposed to purchasing a product or service. So, if someone is paying membership dues to be a member of your organization, or they're paying, conference registration fees, they are paying for a service. They're not intending to make a charitable contribution. So if there's no donative intent, then these rules do not apply. Of course, it also means that the donor is not going to be able to take a charitable tax deduction. But assuming there is donative intent, then there's two different rules. One of the rules says that if someone makes a contribution of $250 or more, a single contribution, then you're obligated to give them a written, basically charitable tax receipt, acknowledging the contribution. And they are not allowed to take a charitable tax deduction without doing that. Now, granted, most C3s are in the habit of acknowledging everyone's contribution, even if it's as small as $25. But technically, if someone makes a $25 contribution, they can take a charitable tax deduction without getting a written receipt electronically or otherwise from your organization. But if it's $250 or more, you have to. But then there's a second rule that says if someone makes a contribution more than $75 and they get something of more than de minimis value in return, that's what's called a quid pro quo contribution, meaning they're getting something in return. There's still donative intent, but they're getting something in return. So for instance, someone makes, a $500 contribution and they get admission to a dinner, a charitable dinner that you're hosting, in exchange, for one person in exchange for the $500 contribution. In that situation, it's more than $75. They're getting something in return. And so not only do you have to provide a charitable tax receipt in writing, but you have to also disclose the fair market value of what the donor is getting in return. And keep in mind, a lot of my clients get confused about this. It's not the cost to you, it's the fair market value. The cost is often less than the fair market value. In some cases, the cost could even be more than the fair market value. The cost that your organization pays is irrelevant. Even if your organization doesn't pay anything, because it got something donated, whatever the fair market value of what the donor gets in return, that has to be disclosed in that written charitable gift receipt. So, for instance, in that example I gave with the dinner, someone makes $500. Let's say you determine that the fair market value of the dinner that someone's getting, dinner and drinks, is $150. Then you thank them for the $500 contribution. You tell them that the value of what they got in return, the dinner, is $150, and therefore they are eligible to take a $350 charitable tax deduction for that. There's lots of different good samples and models out there online if you need examples of how to phrase that. But that's the bottom line. Lauren, you sent a link to an IRS article on the topic, which I think is one of the ones linked in my article as well. And that IRS article has, the first example says a charity provides a 1-hour tennis lesson with a tennis professional for the first $500 payment it receives. The tennis professional provides 1-hour lessons on a commercial basis for $100. So therefore, the charity has to disclose in writing that the fair market value of what they got in return is $100. Usually pretty straightforward, but just it's very, very important to keep that in mind. There are penalties on charities that fail, that the IRS can impose for failure to honor these both of these requirements: the $250 or more for any contribution, and the over $75 contribution when they get something of more than de minimis value in return. And if you're wondering about the de minimis value, there are 2 IRS revenue procedures, one from 1990, one from 92, that are cited in that IRS article, that talk about, how you determine if something has what the IRS calls insubstantial value. And basically, if it's something very small, then it's likely not going to have to be thrown into the mix in terms of ascribing value to it in that charitable gift receipt. So someone asked a question: do you have guidance how to tell a member whether membership dues are not taxed? Yes.
Oh, sorry. That's sorry. I think you're about to. Our specific question is about membership. No.
Lauren, you asked the question, so you get the first one. Yes.
I think our specific question was around membership dues, because the person who was asking was an individual and not a foundation. So if a foundation pays membership dues, that's deductible from their 5%. That's part of their 5% payout. But if an individual gives it pays membership dues, they are getting something in return. That is not a donation. So I think our thought was, at that point, it is not tax deductible.
And just to add to that, a DAF as well. Today we had a DAF ask the question.
Okay, so a lot to unpack here. First off, not all membership dues and not all membership in nonprofits is the same, right? We represent a lot of nonprofit tax exempt trade and professional associations. Some are C3s, a lot of them are 501c6s. Think of your classic membership associations: National Association of Realtors, National Association of Home Builders, American Institute of Architects, American Medical Association. These are all C6s. So there's no issues about charitable deductibility. Clearly, there's no donative intent. Definitely the members are getting something in return. But there we don't deal with this issue because they're not 501c3s and there's no donative intent regardless. In a 501c6, though, typically, it's not always, but typically most members that are making payments to a 501c6 organization, or even a 501c3 that's offering true valuable member benefits, you get a monthly newsletter, you get discounted access to the conferences, you get, you know, other educational materials and free webinars and other stuff like that. Those are real things of value. But if the member, you know, say it's their professional association or something, they're usually going to be able to take a business tax deduction for those payments, which, you know, frankly, is even more valuable than a charitable tax deduction because there's no limits on business tax deductibility. But for sometimes with some C3s, like for instance, I believe this is the case with the Smithsonian, which is actually, some people think it's a federal government entity because it gets a lot of federal funding, but it's not. It's a private 501c3 nonprofit. You can be a member of the Smithsonian, but you're not getting any real member benefits in return. You might get like some early access to new exhibits that are open and things like that. And the IRS actually has some guidance out there. It's not in that article that I was just looking at today, but I've seen it elsewhere. That says, oh, no, actually, I think it's in the insubstantial value part, that the revenue procedures I referred to that talk about insubstantial value. And they say, like, actually, yeah, it's listed right here. The donor makes a payment of $75 or less and receives only annual membership benefits that consist of like admissions to events that are open only to members, and the cost of the per person is within the limit for low cost items discussed in the insubstantial value. Basically, if it's something like that, then they probably are still going to be able to take a full charitable tax deduction for that because the benefits are so low. So sometimes membership is just another way to kind of honor, recognize donors. You know, it's not true classic like membership association membership benefits. So in that situation, these rules are still going to apply. You have to apply them just the way I described them on a case-by-case basis. If I think the question was if the payment came from like a private foundation that has you know, has to spend 5% of their you know, their investment holdings, you know, their each year, there's a minimum 5% payout. If someone is, you know, if a private foundation is paying kind of quote membership dues to your organization, but they're not getting any real membership benefits in return. It's really just effectively a contribution that you label membership. Yeah, that should be able to count toward their 5% distribution. But again, you should not be ever giving them tax advice on that. That's for them to figure out. The IRS says all the time, don't tell donors whether they definitively can or cannot take a tax deduction, whether a private foundation payment is going to count toward their 5%. That's for them to determine because it's going to be different for every particular organization is going to have a different analysis. And Maurice, in your question, you said, I wasn't sure if you were implying that the private foundation is still a C3, so it doesn't take tax deductions. It's not an issue about that. Are the rules different for donations versus DAF?
It should have said foundations. So foundations, which we know, but then DAFs and individuals may be a little different, it sounds like.
So all 501c3s are subclassified into private foundations or public charities. And it's more desirable to be a public charity, and you can get out of private foundation status and be a public charity if you can show that your revenues come from lots of different sources as opposed to like one big source. Think like big corporate foundations, like Fortune 100 companies that have their own foundations. Those are all 100% typically funded by the corporation or a family foundation or something like that. And private foundations, unless you're a private operating foundation, all other private foundations have this 5% annual minimum payout requirement. A DAF, a donor advised fund, that is by definition a public charity because it's, you know, a donor advised fund within a 501c3 public charity. So they're not going to be subject to the 5% rule. But I think is your question, if you get like a donation or a grant from any tax exempt organization, it doesn't matter for this purpose whether it's a DAF, it's just a straight up 501c3 public charity, like your organizations, presumably.
What about like an individual? Like some of our members, their members are like individual donors who don't have a foundation, they don't have a DAF, they're just an individual, and they're, you know, as you know, most of our organizations that are associations in our network, they're more the C3 types. They're not the C6 professional.
Sure, no, I know.
And I know and I'll just say now, because we've talked about this before, there's been this longstanding sort of thing in our network to say, there's different tiers of membership. So if the top tier is 10,000 and the lowest tier is 1,000, they've been saying the value of membership is 1,000, so that you can then take everything else above that could be tax deductible. I don't know how that got out there, but some of our members are trying to figure out different ways to answer that question, whether it's for an individual or sometimes the corporate members have.
Yeah, so first off,
Yeah.
just say these rules about, the having to provide this charitable substantiation is what the IRS calls it. They only apply if we're talking about an individual or a for-profit business. Basically, people who would be eligible to potentially take charitable tax deductions. If the money's coming from any form of tax-exempt organization, these rules do not apply. Okay, so keep that in mind. But yeah, if it's coming from an individual, and if the membership benefits are real, but they're not de minimis, they're more than de minimis, then yes, you do have to put a value on it. You do have to disclose that in return and let the donor know the value of the membership benefits, whatever you determine that the fair market value of those membership benefits is. If it's a $10,000 contribution and they get $1,000 worth of membership benefits, then assuming there's donative intent, and there typically would be, then they should be eligible for, a $9,000 charitable tax deduction for that, whether it's an individual or corporation.
So that's just up to us. That's just up to the organization to figure out in whatever way they want to, whatever method they think is fair.
Yeah, the IRS says you're supposed to just use your best reasonable efforts to ascribe a fair market value. Sometimes it's easy because, you can, say they're making a $10,000 contribution and they're getting, say it's a company, a for-profit company, and they're getting 4 ads, in your quarterly newsletter, one ad a quarter. It's generally going to be pretty easy to determine the fair market value of those ads because you're likely selling those ads to others for a fee. And so you can figure out what that fee is pretty easily. Other times it's going to be a lot more difficult. It's a lot more amorphous. There's no clear commercial value out there for something. You just use your best efforts to try to put something on it. And look, the bottom line is, as long as you're being reasonable about it, you're using your best efforts, and it kind of passes the smell test, it's highly unlikely that either you or the donor would ever get challenged on that. Yep, Joanne, you have a question?
Thanks. Yes. Hi, Jeff. Well, a quick comment. We've been told definitively by the huge community foundation here that DAFs can't pay dues out of, out of the DAF. And so we get around it because they always have foundations, or the foundation pays it for the DAF, and there's workarounds. But anyway, I haven't thought about this question for a while. It's really confusing, I agree. But my question is about something really timely. I'm just wondering how much you're thinking about the exposure that all of us have, including people on this call, to the 2 Supreme Court cases on affirmative action, if they do end up being considered more broadly. I'm thinking we'd only be exposed if we get federal funding, but if we're doing racial equity work and being really explicit about the language, and are we targets? And I'm a little less worried about the foundations than I am our organizations. Not that I'm worried, but we are having a board meeting to talk about this on Monday. We've got a legal brief that's super long. There's a Chronicle piece that came out yesterday. What are you thinking? I mean, for the forum, even in terms of its work and the members of the forum.
Yeah, first off, and you were the one that sent the question in early about this, right?
Yes.
Today. Yeah, no, it was great. And I actually had a chance to skim through the 2 articles, or one was a memo from some lawyers on the topic. First thing I'd say is it's premature, because you got to wait until the ruling comes out. Number one, and we're talking about the two cases, one involving Harvard and one involving University of North Carolina, about affirmative action in college admissions and the ability to consider race as a plus factor in college admission procedures. So, number one, those cases are solely about that issue, and on their face, they're going to be limited to that. But like with any other court ruling, Supreme Court or otherwise, depending on the basis for the decision, the reasoning behind it, how it's written, so many different aspects to it, it could later be used and relied on for others to bring cases in other areas to try to expand, this principle, because I'd say most court observers believe that the U.S. Supreme Court is likely going to ban the consideration of race as a plus factor in college admissions. Plus factor meaning essentially giving preferential treatment to an admissions candidate that is, part of a racially protected class. But whether that could be extended more broadly in other areas is possible. And while I'm sure most, if not everyone on this call, is likely not going to be thrilled with that sort of a decision, and would not likely be thrilled with an expansion of that basic principle to other areas, and I'll talk about those. The memo talked about 4 different areas where it could involving nonprofits where it could possibly be extended, and I would say none of those are out of the realm of possibility. I don't think that those are like crazy, overly eager lawyers, thinking that this is going to spread, into so many other different areas in the future. I think they're all possible. I would probably say I don't see any 4 of those as being highly likely, but I think they're all possible. Wait, hold on. I think they're possible depending on how far the court wants to take these principles. So first off, and I know some of the concern was about are we going to be able to continue to do DEI trainings for staff and board members and other things like that. I think with things like that should not be an issue. But there are other places where it could come into play, depending on how far the court wants to go. So this really has to do with an interpretation both of the Equal Protection Clause of the Constitution, as well as Title VII of the article talked about Title VI. I think I mean Title VII. Yeah, Title VII of the Civil Rights Act is a typo. And basically interpreting both of those and what those mean. So for instance, Title VII of the Civil Rights Act makes it illegal to discriminate against someone in the employment context on the basis of race and other protected characteristics. So it's illegal to not hire someone because they're African American, right? We all know this has been in place since the late 60s. And that's not going to change. But the question is, could the court interpret this more broadly to say it is illegal to give, preferential treatment to an employee because they are African American? If you have 2 equal candidates and you can only promote one and they're both equally talented, equal performance reviews, equal levels of experience, can you use race as a factor in promoting the African American person over the white person? It's not inconceivable that this Supreme Court could take it down that line in the future and make such a, it's not going to be readily apparent from this ruling if it comes out, even if it comes out the way we think it's going to be. But down the road, it is possible. But I would say in that example, and I'll give you the other 3 as well, unless this decision is completely different than most people expect, I would not think that as of the day after the decision that you needed to do anything different in your practices in this regard. None of you, I'm assuming, are not involved in college admissions and things like that. Unless you're involved, you're a college or university and you're involved in admissions, that'll have an immediate effect. on policies and practices and procedures and whatnot. But for the employment setting, if you receive federal funds for contracts generally, and with respect to your C3 tax exempt status, while there are potential implications for all of this, depending on how far the court might go in the future, you know, I'm not going to be advising any clients to make any changes in any of these areas the day after the decision. I just think it's way too much of a stretch. But you know, for instance, there's this federal law. A lot of people aren't aware of it. 42 USC section 1981 is the code section, which prohibits discrimination in the making and enforcement of contracts. And for instance, you know, so the article, the memo was talking about like a foundation that makes grants. Could it be deemed to be illegal for you to use, say, the racial composition of a potential grantee's board of directors? Say, you know, would it be illegal for you to favor your grant making, which is going to result in a contract, you know, to a grantee that has a more racially diverse board, right? That's kind of the question raised there. You know, when you receive federal funds, you're subject to a whole bunch of different requirements, you know, as a result of that. And so, for instance, the article talks about a nonprofit that receives federal funds to open a domestic violence shelter in a minority area, like a community that's largely comprised of minorities. Would you not be able to consider race as a factor in hiring counselors to work at that shelter if you're using federal funds to do that? You know, that's another example. You know, I talked about the employment example. And then the fourth example they give is, you know, for 501c3 status generally. And what it's saying is like, could there be a change that could significantly affect an organization's ability to continue receiving its 501c3 tax exempt status? For instance, if, you know, your purpose or mission as a C3 is advocating for the promotion of persons of color into positions of leadership, and there are a lot of C3s that are out there, you know, that's their mission and purpose, to promote minorities in certain areas, you know, could that be viewed as impermissibly discriminatory under these decisions? As you can probably see, these are all kind of stretches. I think we can't rule any of those out in the future, but they're pretty big stretches from where these two decisions, companion decisions, are likely going to come out. And I would not get into a tizzy worrying about it right now. I would certainly not rush to make any changes in policies, practices, missions, everything else. But it's something to keep an eye on. Without question. And, you know, this court has, you know, gone down certain paths that, you know, would have been almost unthinkable, you know, 10 years ago or more. And anything like this is possible. But anyway, I think I've said enough on that. Does that help?
Yeah, it does. And I think the federal, that's why I asked the question about federal funding, because that isn't, we don't get any. And but we are getting questions, like, you know, the Women's Foundation has a Women and Girls of Color Fund. It's their biggest focus area right now, you know, whether that's something that people will come after. But it sounds a long way, yeah. We'll probably...
I think it'd be a long way at the federal level. Now, as you probably are well aware, all of you, at the state level, in certain states, you know, Florida, Texas, some other ones being most notable, you know, they are passing laws and issuing executive orders and other things that are having an effect on things like this, including DEI related initiatives and whatnot. And so that is something that I think is a more immediate concern, you know, to organizations that either are located in those states or operate programs in those states. And that's something to, you know, carefully watch.
Great, thanks.
Sure.
Thanks, Jeff, and thanks, Joanne, for the question. Wanted to just, if you have a follow-up to this, before we move on, welcome you to raise your hand. We're not a big group, or just speak up and give a minute for that. And if not, welcome. The two questions we got ahead of time have been addressed. So if you have something else on your mind, feel free to ask it of Jeff now.
Anything's fair game. And let me post in the chat. I mentioned that article about unrelated business income for nonprofits. The article I wrote last year that is a pretty thorough explanation of all of that if you're interested.
Mhm.
Can we go back to the employee handbook? Just a quick question, because we talked a lot about it. I was on some of the calls last year. If we have the local employers council and the legal help us go through all that, do we also need an attorney? How much liability is there? Because we're going back to just the straight, terribly worded legalese because it's too hard. It's too hard to do the one I wanted that infuses our culture and makes us seem like a loving, caring place. We're going to have that in a separate. I'm still kind of up in the air, like, how do we do this without overthinking it and spending too much money?
Well, I will say that in my experience, and I have a lot of it, the norm is for nonprofits to have an employment lawyer or a lawyer who specializes in employment law review your employee handbook on, at least, I'd say every 3-year basis at a minimum, because there are constantly changes in federal and especially state, and sometimes even local employment laws. And with the widespread use of remote workers now, keep in mind, I said this on multiple prior of these webinars, unlike, for instance, your nonprofit organization from a governance perspective, it's governed by whatever state in which you're incorporated. DC. So if you're incorporated in DC, even if you have employees all over the country, even if your office is in Chicago, if you are incorporated in DC, then from a governance and other related issues, you're going to be governed by the DC Nonprofit Corporation Act, period. Other laws are going to apply based on where your headquarters is. Like, for instance, we talked earlier about 501c3 federal tax exempt status. But there is also, if you want to be exempt from state corporate income tax, you have to generally, it's almost automatic if you're a federally tax exempt, but you usually have to apply for that and file a copy of your IRS determination letter with whatever state you want to be exempt from state corporate income tax. That's going to be based on the state in which you are headquartered. Even if you don't have formal physical office space, you have to kind of pick a headquarters state, and that's the state that you're going to use for state corporate income tax exemption. But from an employment perspective, it is all based on where the employees are located. So even in the DC area, where I think most of us are located, a lot of nonprofits have employees in DC, Maryland, and Virginia. They all have very different employment laws. Virginia especially has very different employment laws from DC and Maryland. DC and Maryland tend to be more employee friendly. Virginia is more employer friendly. But each one of those employees is going to be governed by the state in which they principally work. And if they work remotely from their home, if their home is in Maryland, Virginia, DC, those are the laws that are going to govern. And so your employee handbook has to be tailored to each of those. It has to stay, because sometimes these state laws have different provisions. So in one section, it might say, like for paid leave, DC has this paid leave law, which Virginia does not. So your employee handbook has to distinguish between the two. This has taken a lot of work for a lot of nonprofit employers, as a lot of them have let employees remote work from anywhere that they want. A lot of employers are now restricting where employees can work from because of this, because of all of the burdens. It's not just the employment laws. It's all the, registering for, state payroll taxes and unemployment compensation and workers' comp and everything else. There's a lot of different qualifying to do business as a foreign corporation in that state. There's a lot of other requirements that go along with it. But bottom line, unless you have an HR consultant who, is not a lawyer, but is just really up on all of this stuff, and that's rare. That's not the norm. I really think it's important to have an employment lawyer review your employee handbook. Look, employment claims are the #1 source of litigation against nonprofits by far. It's always been that way. It always will be that way. And as such, think of employment and your employees as your biggest legal risk facing the organization. And what is in your employee handbook matters. It matters all the time. I was on the phone with the CEO of a client earlier today talking about, actually I had 2 different calls with 2 different CEOs of different nonprofit clients talking about termination of employees. And I was asking them about certain provisions in their employee handbook. You know, like for one, it's my personal bias, but I am not a fan of putting in your employee handbook a provision that says we will give X amount of severance pay to every employee who's, you know, involuntarily terminated. Because what it does is it ties your hand. First off, you have to do it for everyone. But secondly, because you're essentially guaranteeing that to them from the moment they start working for you, that if you want to offer them severance pay in exchange for a release of all claims, it's going to be binding, then you have to give them something above and beyond what they would otherwise be entitled to. So you have to give them even more severance from that. And you can actually get yourself into trouble from a discrimination perspective if, you know, say you're off, say you don't have anything in your handbook. This is another question I was asking one of the CEOs, you know, what's been your practice in the past in terms of offering severance? Because some nonprofit employers, even though they don't have it in their handbook, their effective practice has been to offer a certain amount of severance pay to every employee who's terminated. And if you do that for 5 employees in a row, and then you choose not to do it for the 6th one, and that 6th one has any protected characteristic, you know, female, race, age, over 40, you know, you name it, there's tons of protected characteristics. You know, they might claim, and they sometimes do claim, that you discriminated against them by not offering severance when you offered it to the 5, you know, white employees who were terminated before them. You get the idea. But anyway, bottom line, it's my way of saying that the employee handbook matters. It's really important. There's a lot of things you can put in there to protect yourself from an employment law perspective. There's also things you can put in there about confidentiality, imposing obligations even once they leave the organization, things in there about your reference policy, things in there, you know, from an intellectual property perspective. There's lots of different things that you can and should have in your employee handbook, and it's really hard for me to justify not having an attorney review it. I know that, you know, a lot of your organizations are on the smaller side and don't have tons of resources. I get all of that. But to me, if you're going to pick some areas we're going to use legal counsel and some where you're not, obviously you can get pro bono legal counsel, that's great. But if you can't, this is one area where I would not skimp.
Thanks, Jeff. There's
Uh,
2 questions in the chat there you may see.
Yeah.
First is
see if
best
this-
practice for a quorum.
Well,
for
let's stick
amending-
with the employment stuff for a second
Okay.
before we move on.
The part-time versus full-time designations. Are there state
There are
variances?
state
in
variances
that?
and what full-time, part-time designations are. So, and first off, not that I'm aware of. This is more a, you have to set your own rules, because generally what we're talking about is whether an employee is eligible for benefits, for employee benefits. So for instance, if you as an employer wanted to offer the same benefits to all employees, whether they're full-time or part-time, you could do it. If you want to say, like most employers do, we're only going to offer them to full-time employees, you can do that. And I can't say this for sure. There might be some states that regulate this. It's not regulated at the federal level, but there might be some states that regulate it. But generally speaking, you can define what full-time means. You know, 30 hours a week or more, 40 hours a week or more. You know, you can define that as long as you enforce that on an objective or consistent basis. But again, let me qualify that by saying I'm not absolutely certain that there are no state laws that regulate that issue. I will say that, for instance, it's not full-time or part-time, but it's related to this. I'm sure you're familiar with the concept of non-exempt employees. This is regulated at both the federal and the state level. You know, basically, you're a non-exempt employee unless you can qualify for one of the exemptions. And if you qualify for an exemption, then you're not subject to the requirements that apply to non-exempt employees, the most notable one being overtime pay, which at the federal level means, you know, time and a half for any hours worked over 40 hours in a week. But at the state level, not every state's treated that way. Most states do follow the federal construct there. But California, for instance, says for non-exempt employees, you have to pay overtime at time and a half for every hour worked over 8 hours in a day, which is significant because, think of a nonprofit employer that has, their big annual conference, and you've got your staff working, 12-hour days, including non-exempt employees. And say, these employees reside in California, because they'd only be subject to those laws if they reside there. Now, if you just happen to be, they reside in DC, but you're having your conference in California, that's not going to apply. But if they are California-based employees, then, your typical practice of saying, okay, we're going to work 12-hour days for 3 days, and then we're going to give you the rest of the week off. That would typically be a way to avoid paying overtime in most states, but that doesn't work for California because it's calculated on a daily basis. So just something to be aware of. And there are a lot of unique kind of state wrinkles there when it comes to employment law. All right, bylaws. I love this topic. We're undergoing a bylaws review. Is there a best practice for a quorum for membership meetings or committee meetings? Well, you forgot the other big category, which is board meetings. So a few things on bylaws. There's a lot of bylaws I could go with. My colleague Nisha actually seems to give about one presentation a month on nonprofit bylaw issues. She loves bylaws. She lives and breathes it. And there's so much nuance here. There's so many tips I could give you. This is a very limited question, but it's a good teaching opportunity to say, and this is nonprofits make mistakes all the time in this area, where you have members that have voting rights. Okay, now some of your nonprofits have members, I'm putting in air quotes, but they're not members for purposes of state nonprofit corporate law. They're just members. You call them members, but they're really just donors that you slap the member label on there. But in your articles of incorporation, most states require that when you incorporate, you state in your articles of incorporation whether or not you have voting members. If you have voting members versus if you don't, makes a huge difference, because under the state nonprofit corporation laws, and remember, you're governed by the one that is in your state of incorporation. If you have voting members, there's a whole other section of the state law, and frankly, there should be a whole other section of your bylaws that talk about the rights of members. Like for instance, in most states, in DC, if you have voting members, only voting members can approve amendments to your articles of incorporation, including a name change, or approve a merger, consolidation, dissolution, or substantial transfer of assets. Those are kind of rights guaranteed by law. Most nonprofit bylaws where there are voting members also give members the right to elect some or all of the board members, sometimes elect the officers, sometimes the right to amend the bylaws, and sometimes a lot of other rights as well. But it's really important to distinguish between member rights and board rights, because if you have members, it's a whole different construct. And when I do a lot of kind of nonprofit board legal and governance training sessions, and I'm always distinguishing between the two. Like for instance, the rules even governing member voting and member meeting are very different than board voting and board meetings. So most of the state laws, including DC, say that for a membership meeting, members can participate. Well, they say it now for board meetings too. Members and board members can participate virtually, but for actions outside of a meeting, like say you don't want to have a meeting, but you just want to, like for a membership vote to elect the board members or whatever, you don't have to do it at a meeting. Most of the states allow you to do an electronic ballot. It used to be called a mail ballot, but now it's usually some form of electronic ballot. It doesn't have to happen at a meeting, and people can vote electronically. They can also use proxies, give someone their proxy to vote on their behalf. Whereas the state laws in most states say for board meetings and board actions, if a board is not having a meeting, the only way they can take an action outside of a board meeting is with unanimous written consent, meaning all board members vote in writing and they all vote the same way. And board members are not allowed to vote by proxy. They're not allowed to send a substitute in their place. And that's because board members owe fiduciary duties to the organization. I can explain more later if you're interested, but bottom line is distinguish between, the roles and the rights of members, the rules of participation versus that of board members. They're very different. And then For committees, and I'll get to your specific question in a second, for committees, the state laws also distinguish in most states between committees of the board, sometimes called board committees, versus other committees. Some people call them advisory committees. In many states, including DC, a board committee is allowed to exercise the fiduciary duties of the board. Like the board can actually delegate fiduciary duties to a board committee, but the committee has to be comprised solely of board members. In some states, they'll say it has to have at least 2 board members on there. Some states, it'll say a majority. It just varies. But if it's just an advisory committee or an other committee, then it could be anyone, including no board members on there. And so you want to make sure your bylaws distinguish between those 2 categories of committees. A lot of bylaws we review fail to do that. And then finally, your specific question about a quorum. So a quorum, for those of you who don't know, is kind of the minimum number of participants you need to have either a valid meeting, or in the case of a membership vote, a valid membership vote. As I told you, that board members in most states are not allowed to vote like electronically unless it's unanimous written consent, but members are. But the state laws say that if you're going to take like an electronic ballot of your members, you have to have the minimum number that are necessary to constitute a quorum. And it's going to be the same number that you would have if you had an in-person or virtual membership meeting. Now, again, back to your specific question, we got to always start with the state law. Whenever we're looking at bylaws, like when we review bylaws, there's lots of different things we're looking at, best practices, clarity, making sure we're addressing all the different scenarios, making sure that you don't have too much detail in there that really belongs in policy, making sure the bylaws don't make, your governance life too miserable, too bureaucratic, too difficult, promoting efficient and effective governance. But really, the first thing we always look at is compliance with your articles of incorporation, because your bylaws have to be consistent with your articles. And the other thing is compliance with the applicable state nonprofit corporation statute. And state statutes do address quorum for board meetings as well as for membership meetings and committees as well. If they're board committees, and basically the same rules that apply to board meetings are going to apply to board committees. And these state statutes typically have default rules, meaning if you don't spell out, for instance, what a quorum is for a membership meeting, then the default rule will kick in, which is typically a majority of all members, which is a lot for large associations, for instance, that have a lot of members. But they'll also sometimes have mandatory or minimum things. So they'll say if for a membership meeting or a membership vote, if a quorum is not addressed in your articles or bylaws, then it shall default to a majority of all members. But if you do address it, most of the state statutes say you can't go less than 10% as a quorum. Some don't say that. And we actually have some clients whose bylaws say a quorum for membership meetings is whoever shows up. That's a quorum. And that's permitted by some state statutes, but some say you can't go lower than 10%. So you want to make sure your bylaws reflect that. For board meetings, I'm trying to remember if the state statutes typically have a minimum. I honestly can't recall, but I can tell you that the norm in most nonprofit boards is a quorum for board meetings is a majority of all board members. So, if you have 12 board members, a majority is going to be 7. So the best practice, I'd say, for a quorum for board meetings and board committees is going to be a majority of all members, but also look to your state statute to make sure that whatever amount you're setting is permitted by the statute. And for membership meetings, this is a bit all over the place, but one of my pet peeves is, and I literally just dealt with this issue yesterday for a client, they are looking to do a potential combination with another nonprofit organization, kind of a joint venture almost, where the CEO of each organization would serve, CEO or some other designee would automatically serve on the board of the other organization to kind of facilitate closer collaboration, communication, et cetera, between the two organizations. But in their case, their articles of incorporation and their bylaws, the articles, and it's unusual to have it in the articles, but they're both very specific about who's on the board and how board members get elected. And they don't allow for this construct of just putting some CEO from another unrelated organization on the board. So it would require an amendment, both of their articles of incorporation and their bylaws. And I'm sure you're not surprised where I'm going with this. Both of them can only be amended by the members. It's always the case that articles by law can only be amended by the members. But for bylaws, it's really up to you. It could be amended by the board alone, could be amended by the members alone. In their case, the members alone can amend the bylaws, or it could be both, or it could be either. There's kind of 4 different constructs you can use. But on top of it, to make it even worse, their quorum for amendment of the bylaws, so it's not just any membership vote, they have a specific quorum requirement for amendment of the bylaws. It's 30% of all members, which isn't too bad. But in their articles, they have a specific quorum requirement for amendment of the articles, and it's 50%, which is a very high number for most membership associations, including theirs. So it's just a nightmare to try to get that many people to vote. And so one of my pet peeves when it comes to quorum requirements generally, and especially for membership meetings, is to make sure your quorum requirement is not set too high. Frankly, if you're comfortable with 10%, I'm good with it. Some organizations, feel like they really can't go below 25%, or it's not really reflective of the membership. I'm generally good with that, but I'm really not a fan of anything over 25%. And again, for board meetings and board committees, I'd say a majority of all members. I see a couple other related questions here. How are virtual meetings addressed in the bylaws? So again, distinguish between virtual membership meetings and virtual board meetings and board committee meetings. You want to make sure you address both. This is something that came up during the early part of the pandemic a lot, and actually wrote an article that's on our website all about this topic. This is an area where it's surprising how many of the state nonprofit corporation laws have not come into the 21st century. And some of them don't allow virtual meetings, typically of the membership. They've typically allowed virtual meetings of the board, either telephonic or video these days, as long as everyone can simultaneously hear each other. That's been, generally the rule in most states for many, many years. But for membership meetings, surprising how many states have either they prohibit it altogether, or they have odd requirements. There's one state, I forget which one, that says you can only do it if it's provided for in your articles of incorporation, not your bylaws, but your articles. In New York, then Governor Cuomo issued an executive order basically overriding the state nonprofit corporation statute to allow for virtual membership meetings during the pandemic, which was crazy that they had to do it. And I think later it was codified into law. But bottom line is, as always, check your state statute first to see what's permissible and what's required, because some of the state statutes say you can do it, but it has to be provided for in your bylaws in order to do it, whereas others say you can just do it generally. But it's certainly a best practice to make sure you expressly check your statute to see what's permissible, and then make sure you expressly provide for it in your bylaws, and distinguish in both in the membership section and the board committee section. And then Joanne says, we revised ours so virtual meetings are covered and electronic and email votes.
Sorry, I'm not an attorney. Ignore me, but we handled all that before the pandemic.
Yeah, bottom line is this is an area where I talked about bylaws wanting to make sure your governance is effective and efficient as possible. And this is a perfect example of it. You want to give people as many opportunities to participate as possible. I'm a big fan of doing whatever the state law allows, provide for it. Now, we were working on bylaws last year for an association client, and we asked the CEO, my colleague Nisha and I asked the CEO, your bylaws don't allow for virtual participation at membership meetings or even proxies, even though the state statute allowed for it. But he said, no, that's a very deliberate decision on their part, because they basically don't want people voting on things unless they care enough to show up in person at the meeting. It's kind of an old school way of looking at it. There's a lot of politics involved in that decision, but that's what he and the executive committee wanted to do. So that's what we stuck with it. But generally speaking, that's unusual. Allowing as much and easy participation as possible is kind of the norm and best practice these days.
Thanks, Jeff. We are another hour flew by with you. I'm sure we could keep going, but I want to respect everyone's time. Jeff, thank you for spending this time with us. Thanks everyone for being here. We will be providing this recording to our members afterwards, and Jeff's email's in the chat if you want to reach out to him directly. Take care, everybody. Enjoy the rest of the week and in the summer, and be well and safe.
Thank you. Great questions, everyone. Take care.
Take care.
Thank you.
Bye-bye.
See you, Christine.